certainly have fears that there is a serial killer at loose in Perth.
Sarah Spears, Jane Rimmer, Ciara Glennon.
And every time you saw a young girl walking by, you think, oh God, is she going to be the next victim?
Now, one man stands accused.
If police are right and Edwards is the Claremont serial killer, he's been hiding in plain sight for 20 years.
Today, Defence continued to cast doubt over the DNA evidence, with Mr Yovich saying, without it, all the other planks fall away. Welcome to day 91 of Claremont in Conversation. You're with Natalie Bonjolo, Tim Clark, Alison Fan, and we're welcoming back leading criminal QC Tom Percy. Thank you for being with us. So,
my pleasure.
Tom, we might start with you. It's still quite intriguing to us that Mr Yovich chose not to present evidence during the trial, but I guess we see now in closing we're hearing a really detailed attack on the prosecution theories and particularly the DNA evidence.
Well, that's right. I wasn't surprised he didn't give evidence, as I think I've said before, nor was anyone in the profession. It's a fairly standard way to deal with these matters, and I think if you really can't contribute anything to what happened, then why would you give evidence?
Yeah. I mean, I guess, can you shed some light on maybe what would be the reasoning for maybe not calling the defence calling their own independent DNA expert?
Well, if you think that you've created enough doubt on the prosecution case, and old lawyers always told me when I was a young kid starting in this game, you find your answer in the prosecution case, not by calling your own witnesses. And I think Yovich just thought that, and I'd imagine he probably had some witnesses lined up, it can't get much better than this. Mm-hmm. And at the end of the day, you only have to be able to create a reasonable doubt about it, and you get off.
And that's exactly today what Paul Yovich did. He pointed out repeatedly that the burden of proof is on the prosecution case, that all they have to do is point out the areas of reasonable doubt, and he went very, very heavy on the DNA by going back to the PathWest and all their flaws and mistakes. And he said, we don't deny that DNA was on this fragment, this nano piece of scraping, but it got there through contamination, through over the years of them taking out the samples, opening, closing them, etc., and that's where it happened. And he said, that's what we have to point out to you, Your Honour. Look at the big picture.
Yeah, so Tim, right off the bat today, Mr Yovich hit straight up with this cleaning regime at PathWest and whether the results can really be trusted.
Yeah, well, that's right. And we heard a lot about that during the actual body of the evidence when Scott Egan from PathWest was there, and other PathWest witnesses as well. And he really honed in back on those 10 contamination events that he brought up and highlighted at length during the trial, and then tried to paint a picture of sloppy workmanship, sloppy cleaning regimes and sloppy record keeping, and pointing to all that and saying, well, Your Honour, it only takes one of these events to have happened to potentially lead to an injustice. And as we've discussed before, he hasn't come up with a scenario or a timeline which could possibly have led to this contamination, but as we've already said many, many times, he doesn't have to. And that is why Ms. Barbara Gallo spent a lot of time at the start of the week trying to discount this theory, this contamination theory, presenting a timeline that she says makes it impossible for that to have happened. So, yeah, we're really getting the flip side of the coin at the end of the week, where we got the shiny side at the start of the week.
So did Justice Hall ask for clarification on that? Because in the prosecution case, these 10 contamination events, most of them were explained, were they not?
Yeah, well, explained, yes, not excused. I think that's fair to say. 9 of them were direct staff member to exhibit contaminations. So all the staff members at PathWest obviously had their DNA on record for just such an occurrence. And when these were tested over the journey, right up to 2017, 2018, 9 exhibits of various shapes and sizes were found to have staff member DNA on them. 4 of those were Laurie Webb, who was in charge of the controls at the PathWest at the time, and the crucial one that the prosecution started with in their counter arguments at the start of the week, and the one that Mr. Yovich ended with today was this cross-contamination, case-to-case contamination, if you like, where this vegetation that was on Jane's body was said to have somehow got a victim's DNA from a completely unrelated case on it. And that was, and that's the one that Justice Hall really honed in on today, was saying, well, the 9 with the staff members, they're explainable because they're either handling exhibits or in close contact to exhibits. But this 10th one, the one with the vegetation on, I think is the one that he will really turn his mind to the most, in that is the closest scenario to what the defence say may have happened to Ciara's fingernails.
Tom, how important do you think that 10th contamination case is?
Well, I've always suspected that there were problems down at that laboratory for the best part of a decade, and when the Laurie Webb matters came up, it only served to galvanise me and a number of members of the profession to the effect that, you really need to look very, very carefully at this. And I think the things that have emerged during this case may well result in recommendations coming from the court, from Justice Hall, about how these things happen. I think there'll be some trenchant criticism about what happened. But whether or not what Yovich has been able to piece together in terms of the contamination theory will ultimately impugn the DNA evidence that's the axis of the prosecution case remains to be seen. I would have thought that there's a pretty good case that there's been some critical contamination there at some level. Personally, I would not like to be convicted on the sort of evidence that's before this trial.
Okay, and what about the point that Mr. Yovich and the defence team aren't able to exactly point out how the contamination did take place?
He doesn't have to do it, and that's effectively a reversal of the onus of proof. As a defence lawyer, which I am, it's always nice if you can say, look at this. This is how it got there. This is when it got there. But sometimes you're not in a position to do that. All you can really say is, there's a big question mark about this. I can't resolve it. And that's what we call a reasonable doubt.
Yeah, that's exactly what he kept saying over and over. This is the prosecution's strong point. It's there, the burden of proof is on them. And he said, look, there are instances where we realise in hindsight that technology has advanced to the point where it looked almost primitive. Nobody wore face masks. People didn't have the sanitation levels that they've got today. They didn't know about cross-transference and all of that. But it happened, and it's a very dangerous area to convict, and there's reasonable doubt that the contamination could have taken place there rather than, he said, during the fatal struggle between the victim and the perpetrator.
And did Mr. Yovich say that there was doubt that there was a struggle?
No.
Well, he said that was one possible explanation for Ciara's broken fingernail, of course, and he had to accept that. But again, he said, Your Honour, you've got to weigh all that up. Is there any other explanation? And Mr. Yovich raised a couple today. Did she catch a nail on the bar or on a glass at the Continental Hotel? There's no direct eyewitness to say I saw all 10 of Ciara's fingernails intact as she walked out of the Continental Hotel just before midnight on the night she died. So again, they're theories, and that's basically what we've had this week is numerous theories being overlaid onto the evidence that we've got. Justice Hall is being asked, what is the most likely, or what is the most unlikely, and can you be satisfied when you consider them all of guilt or innocence, I suppose.
He did point out that there was no doubt of a struggle, pointing out the defensive wounds on her arms and, of course, the injuries that there was. But he said that was one possibility where her nails pointing out the fact that there were other defensive wounds, that there was indeed a struggle.
Tim, Mr. Yovich also talked about the passage of time and how Mr. Edwards was possibly disadvantaged by that. What did he mean?
Yeah, well, we touched on that briefly yesterday, and I'm sure Tom will be able to speak to it with much more power and authority than me. But this is the concept that an accused person, man or woman, is put at a severe disadvantage the longer away from the alleged crime the accusation comes. And in this case, and obviously that's more than 20 years, and what Mr. Yovich pointed out this morning was the potential for an alibi on any of the nights of the alleged murders, but and he took Ciara's as an example, is denied you because who could say where they were this time last year, let alone on the precise hour of a precise day more than 25 years ago? And that was his point, that Mr. Edwards had been denied the possibility to go back and look at, go back into his memory or go back to work diaries or whatever it might have existed at the time, and look at that and say, well, look, I can show you exactly where I was on March the 15th, 1997, because I was here and I've got this person to vouch for me, or this piece of material to vouch for me, but he can't do that. And that's what we referred to yesterday. It's a Longman direction, which the judge, if there had been a jury, would have given the jury, but now he's got to give himself to remind himself of the tyranny of time, I suppose.
Tom, in terms of the passage of time, would it be reasonable, and many people would ask, to say that the prosecution is equally disadvantaged by a passage of time?
Well, I think about 30 years ago, the High Court had a look at this question in a case called Longman and the Queen in relation to sexual assault. So when a historical allegation comes up, they ruled that you have to look at it from the defence perspective and just see, look, how could you possibly defend yourself about this? Quite often we don't know the dates in question in respect of which these things have happened. And unless you're an obsessive diarist, and I have to admit to being one myself, I can tell you exactly where I was on those nights in question. But he probably couldn't. And it's a matter that a court needs to take into account and weigh into the equation, and the High Court has said that. There have, however, been other decisions of courts which see the same is not the case for the prosecution. They bring the case. They say that you should find the person guilty. They say they can prove it, and they've got to take that consideration into account before they bring the charges. But it's not for the judge to say, oh, look at the poor prosecution, they're hamstrung by exactly the same things as the accused. Right. That's something that only endures to the benefit of an accused person, not the prosecution.
Right. Tim, am I right in seeing that today Mr. Yovich added there was evidence that Mr. Edwards was with his former girlfriend on the night that Ciara died?
Well, he suggested that will be raised later on in his closing submissions, yes. This is a lady that Mr. Edwards had a relationship with in between meeting his first, his first wife leaving him and meeting his second wife. And that wasn't, from memory, it wasn't sort of really explored at any great length during the evidence in chief and cross-examination. But yeah, Mr. Yovich said he is going to point to that and point to that possibility as well. So yeah, that's something that will be of interest when we come back next week, definitely.
Yeah, Tom, I guess this raises that question that we were talking about earlier, that if there is evidence that Mr. Edwards was with a former girlfriend, you know, us lay people think, well, why wasn't that presented during the trial?
Well, you can't rely on it unless it's in evidence, but I think it may arise inferentially from the evidence produced by the prosecution. So I think that's where they go with that. I hadn't understood that there was going to be any alibi evidence as part of the defence, but perhaps I've got the wrong stint on it.
The judge actually said I've got a lot more questions for you, and we're going to have a ponder over that. He asked a few of them to have a good think before we come back on Monday morning. So I think Paul Yovich will probably be quizzed again. He hasn't been quizzed as closely as Carmel Barbagallo was yesterday, which did extend the length of time. But he just said to the end, I just want to clarify a few more points, and we'll talk about that next week. So we wait to see what happens.
It's very important for the judge to be able to isolate all the issues in his own mind and know where both respective sides are coming from so that he can adjudicate on the relevant issues between the parties where the battle lines are drawn. It's important that he asks those sort of questions. He's not disparaging either counsel. He's simply saying, I need to know what you want me to find in this regard and why. And that's a normal way that these things progress.
Yeah, we've had lengthy chats about, the questioning and the line of questioning from Justice Hall and how much we can read into that.
I wouldn't read in too much.
So it's been obviously quite a difficult week, Ali, for the various parties involved. Have the members of the families been quite stoic?
They've been there every day still. I think they thought it was going to end this week. And, of course, with all the questions that Justice Hall is asking has lengthened the time for both parties. And, yes, I think probably maybe Monday, Tuesday.
Yeah. What's your best guess, Tim?
Well, given that Mr. Yovich let slip that he will be outlining some more of his points over coming days, plural. I took that to mean that he doesn't think he's going to finish on Monday. But again, I mean, there's a fairness involved. He can take as long as he wants. And the judge isn't going to hold him to any deadline or any sort of account. He's laid out his sort of roadmap for what the closings would involve, and going back through that just a short while ago, he's only on his first bullet point. So I think we've got a fair way to go yet. Yeah, absolutely.
Tom, many listeners have been asking us how long we think it will take for the judge to reach a verdict. What would be your best guess on that?
You don't know, but I suspect he's been writing the judgment all along, and that most of it's already written. He's just clarifying a few things and obviously listening and taking on board all the submissions that are made. But I think the formal parts of the judgment are already written. I would be surprised if we didn't get a decision within a month.
Wow. Okay. That's interesting. I was sort of maybe thinking 3 months or...
But then that's not over, is it, Tom? Because then he's got to hear submissions about the rape that the accused has pleaded.
That's sentencing. That would be at the same time as any sentencing took place in relation to any verdicts of guilt that he might bring in. So I don't think we need to worry about those ones. The question is, when's he going to bring in the verdict in relation to the murders? And I would think, look, it could be as early as 2 weeks.
Wow. I would love to see the spreadsheet that he's working off.
Yeah, well, it'd be enormous. He's probably had to buy himself a new laptop just to get all this stuff on it, I would have thought. I mean, being an e-trial, it's been slightly easier for him because he's got associates to help him sort of research and look for sections of the transcript that he wants to pour over and other little bits of evidence that he might want to recap himself on. So but Justice Hall has also got a huge filing cabinet next to him as well. So he's got all the information at his fingertips, and that's been illustrated this week by him being able to apparently recall very detailed sections of the transcript, just off the top of his head. So I'm not quite as optimistic as Tom. I think it'll be a bit longer than that, but I don't think he's going to want to take too long for everyone's sake.
Yeah, I mean, either way, he must be burning the midnight oil studying. Sure. Tom, just before you go, we have a question from Jay. As a listener to a lot of true crime podcasts, one thing I've heard a lot about is escalating behaviours in relation to violent crime, e.g. progression from voyeurism to sexual assault to rape to murder. I haven't heard this mentioned during this trial, but it seems to fit the case of the prosecution if we consider Huntingdale, Hollywood, Karrakatta, then Claremont. Is this not admissible as propensity evidence?
I think Jade's been watching too much TV. And, I think that that's not really what propensity evidence is all about. It's an interesting theory that some criminologists have. If the prosecution had wanted to rely on that as being a fundamental premise upon which the judge could act, then they would probably need to call an expert in that field to say that they've looked at all these things and that in their view the behaviour of this person fitted a certain prototype, that from that you can draw an inference that there'd been an escalating scale of behaviour, that was a very solid thesis in criminology and as a branch of science. But I don't think any of it's gone that far. I think we can leave that to the CSI shows on TV.
Yeah, I think you might be right. Well, thank you all very much for today and your time, and thank you for joining us. We'll be back Monday for week 24 of the trial, where Mr Yovich will continue his closing arguments. Join us then for day 92 of Claremont in Conversation.
This podcast is hosted by Natalie Bonjolo, produced by Kate Ryan, and recorded in the studios of 7 West Media. Sign up for daily emails and all the latest on the Claremont trial at thewest.com.au. And if local news delivered differently appeals to you, tune into WA's newest morning show, The West Live with Jenna Clark. It's talkback radio, but without the interruptions. Listen live weekdays from 8:45 a.m. on thewest.com.au or catch up with the podcast.